Serial number
32. First
may not be taken up.
from the last 6 months.
Oh, you want it to be taken up? What is the matter? Date is always there. You want to do it or you don't want to?
My senior will have it tomorrow.
I just want to know, are you interested in doing it or you are not interested in doing it?
My senior will have it.
Who is this?
Mr.
Mr.
Kalyan.
Mr. Kalyan. What is the matter?
The matter is judgment and degree is passed on the basis of the unregistered documents that they are passed the degree. The learned trial.
It's a title suit.
Yes. The execution case is pending.
File details. Show me the file.
We got the file of the trial and the subject material is that against the deciding there are some problem because after some time they will be vacated for that.
Appearance is complete.
Pleadings are complete. So one idea
Pleadings.
also
FA में क्या pleadings? What pleadings? In
because
FA,
also-
appearance is complete or not?
Yes, it's a problem.
On repeated occasions you have been absenting, right? What IA has been filed?
One idea also was for stay of the proceeding in the
And what else? Second IA?
second is for additional evidence.
Additional evidence. What additional evidence are you seeking?
Through applying we have filed, we have obtained some official documents from Rajasthan Municipal Corporation that
Which you could not have obtained during trial. Why?
just on 2016 and 2025.
Where is that IA?
Idea,
Have they responded to this IA?
yes,
They have filed a response to the IA?
no,
Who is the counsel for the other side?
Mr. KK must have.
Which is that IA number? Which is that IA number?
ID number of 2026
ID number 5541 of 26 for additional evidence.
Of 26.
and 8940 is for stay of the proceeding.
Double page 26 का आइए तो यहाँ है ही नहीं. It's not there on board. When did you file it? कब हुआ file?
Last week, Friday or Saturday.
Other side is not here. Post tomorrow. कल आइए 2:15 बजे. आइए पे पहले ऑर्डर करेंगे. We'll take the counter from the IA, and then IA has to be considered at the time of final hearing, and we'll hear you finally.
Also for first half say appearance,
Yes.
they are appearing.
Now, where are they? What's your good name?
Director procession
राजकुमार सिंह
Yes, ma'am.
ने हमारा DSP साइबर का.
You have given me this, right?
Yes. And there are some data are also available regarding the trial of the cases and the conviction.
Okay. Where is that? What is the conviction?
कमिश्नरेट में 3 साल का डाटा हम मंगाया है। एक्चुअली में है क्या कि साइबर क्राइम का पूरी स्टेट में 7 जगह स्पेशल कोर्ट है जो कि रीजन है का उस सातों का वो डाटा जिसमें से एक जगह से विजिलेंस से नहीं आ पाया है।
आप उनको ये बताएं, you are comfortable with Hindi
Yes.
or English, whatever,
Yes,
right?
yes.
You just tell me that when in a cyber case, in any matter, a person files a complaint in the portal, does it constitute an FIR? Is it to be registered as an FIR or not? I filed a complaint. Suppose I filed a complaint that 1 lakh rupees from my account has been siphoned off. Does it constitute an FIR or not? right? Is any separate FIR registered on that complaint or not? And at whose place that FIR is to be registered? In most of the cases I am finding that there is an accused, you seize his mobile and SIMs registered in the name of other persons, you say it is fictitious. And then in the portal, you have maybe 10 victims, right? So these 10 victims are distinct victims at different point of time, situated at different places. How do you say that he does not have any criminal antecedent? How do I get this report that he does not have any criminal antecedent? Rather, he has got 10 criminal antecedents. Yes? Please explain. Either you say that they all constitute one offence. Then I will say that arising out of this FIR, there is no criminal antecedent. I get an antecedent report that apart from this, there is no criminal antecedent. Explain. Yes, madam, you tell me.
Ma'am, in the this error on the part of the IOs, there are two different things. Ma'am, they should write that in the ICJS system, he doesn't have a criminal antecedent, but in the portal, that will constitute a criminal offence.
Each one of them distinct criminal offence?
Yes, ma'am.
Okay.
We regularly guide our IOs to include that, whatever is
They do not.
Yes, ma'am.
I do not get that report. I get a report that he has no criminal antecedent. And in numerous cases, I have granted them bail on the ground that your APP also agrees that he does not have any criminal antecedent, right? That is because he is saying so on the basis of the report. Whatever he is saying, he is giving a report. Then I also find that the antecedent report is coming on the basis of the place he is residing. There could be, like in Devghar, maybe that he has a criminal antecedent in another district, another state also. So these figures are not coming before us. And these, the maximum punishment prescribed for owning a mobile or a SIM based on forged document or created by forgery or whatever, right? If they are not able to account for these devices or whatever it's there, that itself is an offence. So please take care of this. Each is a distinct offence, and I'm also finding that you are asking those officers to take them on remand.
Yes, ma'am. We ask the officers of the other state to take them on production.
Do they come?
Ma'am, they take it through DC. Most of the time they take it through DC.
And then if they are released, then what do you do? Suppose an order of bail is passed by this court. What do you do to them? They are released? Or they are sent to the same state?
They are sent to the other state, ma'am. In some of the cases which I think they are sent to that state.
They should be sent because they have already been taken in remand in another case.
So what I am asking, they are sent to the custody of the other jail unit of the other state, and IO files a charge sheet and he is tried in that state.
So your counter affidavit should specifically indicate all this. And why is it that you are not able to trace the victims?
Victims details are already there on the portal.
No, victims, you say that so many persons, you are talking about transfers and then one victim is there or two victims are there. You have only 2 or 3 victims in each case? Or there are more?
There are more, ma'am. Not necessarily, because on the basis of mobile number and account numbers.
There are 2 kinds of complaints which must be coming in the portal. One is that somebody has made an attempt. That is also a complaint.
Yes.
Somebody has made an attempt, right? There is another kind of complaint that I have been cheated, right? That offence has already been committed. There is one attempt, and other some may say that it has already been committed. The whole purpose of let us see why these people are actually lodging the complaint. Because they know that if the money is tracked, it will be released in their favor. Subject to final result of the case, certainly.
No, ma'am. Subject to the fees, ma'am. And 1,083 intermediaries are onboarded on the portal, ma'am.
Okay.
Victim files a complaint and receives an acknowledgement number. The moment the money is traced to the portal itself, it is kept on freeze. That the freeze information is received by the victim. If it is less than 50,000, he can file a application for reversal to the police station. If more than 50,000, he has to go to the court and file the application, and it is done within 1 week.
That's right. It is done within 1 week. That is why they are filing the complaint.
Yes.
Suppose ultimately the accused is acquitted. what will happen to that money?
The freeze amount will stay and it will go back to the victim. The money which has been
The money will be retained by the victim,
yes, it will be
irrespective of conviction of the accused.
Yes, irrespective whether it is convicted or acquitted, that is one part. Whatever money is freezed from the portal with the help of intermediaries and reversal of that fund is a separate part. It has nothing to do with the acquitted part. That is the SOP, ma'am.
Okay, that it is irrespective of the.
That SOP has been passed.
Suppose the accused says that I had some transaction, some business relation, some kind of relationship. That is why this money was transferred.
Yes, it happens, ma'am. Under that circumstances, we have to send a notice to all the persons before filing a release, before giving an order to the bank to release the money to the victim. A notice is given to the account holders to verify themselves through VC or physically they come to the PS and verify themselves. That is the SOP.
Okay.
That is included in the SOP.
So, do the victims cooperate for the trial? Do they come up?
And if they are situated in other states, ma'am, if there is one bank account of the accused and there are more than one complaint, apart from our victim, there are complaints from other victims of other states also. We have no issues in producing our witnesses to the court.
That's right. But suppose there is a
other
victim
states.
at Maharashtra,
Yes.
500 victims. Let's say he would not like to come over here. You can have his witness recorded through VC. Do you track him and ensure that he is produced as a witness before the court? Because I am informed that there is a lot of acquittals because victims are not coming forward to depose.
We try to make them charge sheet witnesses and someone is sent from the court. But if trial through VC is done, then I think there won't be any problem.
I don't think that there is any problem in. Yes, please explain.
Your Lordship, what happens when maximum cases where the victim was staying somewhere in a different district or a different state, and when they come ahead and there is a recovery of the amount, what maximum happens, they at the time of very bail, they enter into a compromise. They receive back the amount and they enter into a compromise. In that condition, they don't appear.
No, compromise is another thing.
Your Lordship, this is one of the biggest reasons. Is that at the time of bail, where the amount is very
No,
less.
here when we are granting them bail, there is no compromise.
No, Your Lordship, what has happened in last few years we have seen, like in 30,000, 40,000, 50,000, 1 lakh, 2 lakh, even 8 lakhs, 10 lakh. There are victims who have been from US. We have had a conversation with them. They have turned up, but what they have done, 2 of the accused person have compromised with them, and one.
At least they will come to the court and say that they are hostile, isn't it?
Yeah, exactly. This is their duty. But what happens is they send some kind of letter or
No, people in US, you forget, you will not be able to track them. But other witnesses
Other witness
who are within India, how far do you go to secure their appearance in the court?
Your Lordship, they are the mobile number provided in their FIR or in the charge sheet column. We used to contact to them, and we tried that whatever the recording media we have been provided for, like the VC or the GST app, which has been acknowledged. We tried to get their evidence recorded by that.
You see, so far as the witnesses are concerned, you take all the steps to secure their appearance, isn't it? As per law,
Exactly.
right? Till the issuance of warrant of arrest, correct? You don't follow all this for cyber offence?
We follow all, each and every step has to be followed. We have a nodal officer of the cyber CID or of the cyber PS. We give them the notices, along with the mobile number, and they duly serve and they tell the informants to come before.
So, through whom?
To the victim, to the witnesses who are
Through the online mode.
If the witnesses are sometimes by online mode on their mobile number,
And-
they are staying away.
And if they do not come, what do you do?
We used to firstly we try to talk to them and come ahead with their evidences.
So
But what
you are at their mercy. You see, the entire genesis of the case is that there is a victim, and that victim you are letting him go. He is not coming and deposing before the court that he has been cheated or he has not been cheated. Right? He can do either, isn't it?
Yeah.
Then how will you secure their conviction?
Unless until the victim will not turn up and he will not support the prosecution case, the conviction can't be secured.
Can't be secured then? Then what's the big idea of putting them behind the bar when you are not capable of securing the presence of the victim before the court? You see, an accused may have bail, right? By saying that trial is not being concluded, or there can be n number of reasons for that. But you cannot have an acquittal like this. Because of your non-action that you are not able to produce the witnesses. How many victims are from foreign countries? There are only few. Most of the victims are within India. And you have to tell them that you have taken the money by virtue of lodging a complaint. Right? If you say that you have not been cheated, this money has to be returned back. Isn't it? How can they turn hostile? The moment they say that they have not been cheated, or they say that they have not, or they do not support their complaint, then money has to come back. How will they? How under what authority of law will they retain the amount?
Unless and they don't enter into a compromise, they can't retain the amount if they have taken this. It's no doubt very clear.
It is compoundable.
Yeah, section 77, it keeps an embargo.
Okay, fine. They will say that I have compounded it. They'll have to come and say that I have compounded it. I've got the money, so I have no grievance, whatever it is. But you can't have it this way, no? And what is happening that one after another, one person is committing offence one after another. And people are saying in the court that the prosecution is not able to secure their conviction. And we are being put behind the bar. You are not doing the needful. They come out and each one is training others. I have come across a judgment, an order today, where he is saying that I have been trained in a training center. You can't have it this way. If you are not capable of doing it, don't lodge it. Don't do it. And you cannot say that they have no criminal antecedent. This you can't have. Cyber offences are very serious offences. Everybody, I am sure everybody must have come across, you also must have come across one or the other crank calls. Right? You can't have it this way. In one case I was seeing, the state says that they have been cheated. Right? They have been cheated because each allowance has been generated and now the amount has been siphoned off. The money has not come to the state. Right? If these each allowance have been generated in favor of one or the other person who was supposed to pay the money, not even one such person has been mentioned in the case diary. Not like his statement has not been recorded. He will show you that each allowance, no, that I have received this each allowance and therefore there is no dues against me. Not there. When state is the victim, they say there is no victim. In such a case, where the money of the state is being siphoned off through cybercrime, who is the victim? The state is the victim. But there is no investigation in that direction. There is an allegation, like in another case, POXO, that there is a video recording in the video of the accused. You do not seize his video, his mobile. And then they say that there is no evidence of any video recorded in the mobile. We are not here to guide investigation, but I'm absolutely clueless. What are you doing? And in POXO cases, as per the provision of the Act itself, the trial has to be concluded within 1 year. Correct? And SP is responsible to ensure that the witnesses are produced, not less than the SP. Right? Still the witnesses are not being produced. And numerous cases, today also it was coming, that witnesses are not coming. If you are not able to produce the witnesses, do not put them behind the bar. Please do not put them behind the bar. You are not able to produce the witness. Don't oppose the bail. You can't have it both ways. And your madam, you just tell me, whatever I am saying is incorrect. It is for you to take steps. Why should we guide you for investigation? And you can always tell the victim that if you do not come, your money you will have to give back. He can't retain the money by lodging a complaint, and then he will retract the money from the another's bank account, right? And when it comes to giving evidence, he will not come. And we have so many ways and means as to how evidence can be recorded at their own place. They don't need to come to Ranchi or Jharkhand or do anything of that sort. I think that there is an SOP to that effect also. They can go to the legal aid center. They are required to be duly certified and identified, and they will depose. Show me, have you issued warrant of arrest against such witnesses, even in one case?
Your Lordship, on the prayer, the learned courts have issued the warrant of arrest. But what happens at times, there are different circumstances. At times, what happens, the victim is deciding he is a tenant at a house. We get the report that he is no more residing there, his mobile is not working. Second time, what happens, we issue, but he has
You see, you have his bank account. You will get every information from the bank account. Every information. His bank account is there. He may go anywhere. Every detail is there in the bank account, and you have to inform the banker that this money has to trace back because he is no more. He is not coming forward to support the complaint made by him. And the cases are being lodged only when the mobiles are seized in Jharkhand. Do you yourself lodge any case? No. The case is to be initially lodged at the place where the victim is located, right?
Where the offence has been committed, because in cyber cases, ma'am, the cyberspace becomes a view. So for the reason there are different places where the fire can be registered. And what happens that during the money trail, what I have found while reading the case diary, that at times I think she is the she can better explain. But when the money trail, what happens that the money gets fragmented to different branches. Amount of 1 lakh has been cheated. What happens if it passes on to a second account?
That's a organized crime.
Yeah, organized crime.
I was just telling him one day that every case now is not a case of organized crime. At least 2% should be involved. The money should move, or the system should move from one system to another, or two systems or two mobiles should be at a time included to commit one offence. Then only it will become an organized crime. Otherwise, merely because 5 people are sitting together and they are using their phone to do the crime, it will not become an organized crime. For one singular victim, there should be 2 persons involved to make it an organized crime. Otherwise, it will not be an organized crime.
And what I think part of the investigation is first that when the money trail has been transferred, the money is going from account A, B, C, D, E, F, G. Now the most important part of the investigation is to check whether the accounts which were involved in B, C, and D they have been just used as a mule account, or they have used an account to make a path for getting them transferred. So it becomes a part of investigation, ma'am. It happens that till the system is as such that till the IU reaches to the point, there are a lot of evasions. They get the money out from the accounts.
We appreciate that there are a lot of evasions by the time the IO reaches the last point. Fair enough. But the complaint is genuine. Complaint is genuine. So complainant has to be there. Without without the complainant, how do you actually proceed?
With permission,
Yes, please.
What happened in the cyber crime cases? कॉल एक जगह से होता है, सपोज दैट जामताड़ा से कॉल हुआ, मुंबई में कॉल. There are 2 places of offense. Initially, the complaint lodged in the cyber portal, that is गवर्नमेंट और होम मिनिस्ट्री के द्वारा जो रन किया है. जैसे ही वहाँ कंप्लेंट लॉन्च होता है, तो मोबाइल जहाँ रन करता है वहाँ मैसेज फ्लो करता है. कोई अगर बॉम्बे से कंप्लेंट किया, पोर्टल पे लॉन्च हुआ, पोर्टल तुरंत शो कर देगा जहाँ पे रन कर रहा है उसका कंसर्न एसपी के यहाँ वो रन करना शुरू करेगा कि ये मोबाइल नंबर से चीट किया गया. इमीडिएटली वहाँ के प्लेस ऑफ ऑफेंस जो होते हैं वो उस मोबाइल को ऑन द बेसिस ऑफ टावर लोकेशन सीज करते हैं और एफआईआर करते हैं. देयर आफ्टर दे कम्युनिकेटेड कि ये जिस एक्यूज को अरेस्ट किया है, इफ रिमांड और अदर इंक्वायरी रिक्वायर्ड इन योर पुलिस स्टेशन, देन यू गेट द रिमांड ऑफ दिस एक्यूज. एक काम करते हैं. सेकेंड करते हैं कि जो उनका मनी जो ट्रायल होता है ट्रांजैक्शन, मनी ट्रांजैक्शन के अनुसार जो भी जहाँ भी होते हैं, बैंक्स होते हैं या किसी के बैंक अकाउंट में गया, उनको कम्युनिकेट इमीडिएटली करते हैं. अगर अमाउंट कहीं पड़ा हो तो उसको फ्रीज करने का भी नोटिस इशू करते हैं इमीडिएटली. और जो विक्टिम्स होते हैं उसमें कुछ विक्टिम्स इंटरेस्ट लेते हैं केसेस में, कुछ विक्टिम फर्दर साइबर क्राइम नहीं हो जाए इसके चलते अपने मोबाइल को स्विच ऑफ कर देते हैं, कोई भी कॉल जाता है इंटरटेन नहीं करते हैं।
आपको वहाँ पे कंसर्न एसपी के थ्रू ना कराना पड़ेगा।
नहीं, वो भी करता है, उसी को कर देता है। जो भी कम्युनिकेशन होता है प्रोसिक्यूशन का एग्जीक्यूटिव बॉडी होता है, इन्वेस्टिगेटिव बॉडी होता है।
अच्छा एक बात बताइए, अगर मान लीजिए पोर्टल में हुआ कि जामताड़ा के में फोन यूज करके एक क्राइम हैज बीन कमिटेड, ऑन द बेसिस ऑफ दैट डू यू इंस्टीट्यूट एन एफआईआर?
यस, जामताड़ा में एफआईआर इंस्टीट्यूट करते हैं।
इंस्टीट्यूट हो जाता है?
हाँ, इंस्टीट्यूट हो जाता है जामताड़ा में, और उनको कम्युनिकेट किया जाता है।
तो उसका ट्रायल कहाँ होगा?
ट्रायल
जामताड़ा में।
वन ऑफ द प्लेस ऑफ ऑफेंस इज जामताड़ा। यहाँ
लेकिन वहाँ पे जो वो तो एक तो खाली पोर्टल में एफआईआर लॉन्च हुआ, लेकिन ट्रायल नहीं हुआ।
ट्रायल यहाँ पे देयर आर टू प्लेस ऑफ ऑफेंस हुआ, एक जगह से जहाँ से कॉल किया गया और दूसरी जगह जहाँ से चीट किया गया। लेकिन ट्रायल होता है एक्चुअली यहाँ पे एफआईआर यहाँ लॉन्च होता है और उस कंप्लेनेंट को इंफॉर्मेशन दी।
इस मामले में ये बेटर
यस मैडम।
But there are two parts. Victim is in some other state and there is a fraud committed and he lodges a complaint on the National Cybercrime Reporting Portal. That number is reflected through the प्रतिबिंब portal, मैम जो हमारे झारखंड के द्वारा ही मैम लॉन्च किया गया है, उस पर मैम रिफ्लेक्ट करता है वो नंबर्स। अगर लोकेशन के बेसिस पर मैम एक्यूज्ड अरेस्ट हो जाता है, क्योंकि सभी डिस्ट्रिक्ट को उसका क्रेडेंशियल्स मैम को लॉगिन करके द क्राइम नंबर्स वेरेवर दे आर एक्टिव दैट विल शो इन द कंसर्न jurisdiction of the district. So अगर लॉगिन करते हैं मैम on the basis of the location, if the accused is arrested, then an FIR is lodged. Then the concerned victim
After arrest.
after the arrest. Then
Not
this
at
becomes
the instance of lodging the complaint.
accused is arrested, प्रतिबिंब पोर्टल पे मैम ये नंबर रिफ्लेक्ट करते हैं उनके लोकेशंस लेके लाइव लोकेशंस, if they are arrested, every attempt is made to arrest all the accused whose number is reflected on the प्रतिबिंब portal. But
And prior to that, prior to arrest, there is no scope of lodging the FIR.
दैट इज सानहा
Sana.
सानहा रजिस्टर्ड होता है, देयर आर द टू सीरियल
पहले हुआ कि हमसे मेरे साथ दो फ्रॉड थाना में डिस्ट्रीब्यूट हुआ, उसके बाद इन्वेस्टिगेशन में कुछ
and then the place of crimes becomes the place from where the accused has been arrested on the basis
Okay.
of the mobile numbers provided.
As per the protocol, wherever he is arrested, he will be tried there only.
Yes, ma'am. Yes, ma'am. And sometimes it happens that the concerned accused is taken to the other state where the victim has lodged a complaint. The victim appears in his court during the trial. He doesn't come to our place where our trial is still pending. So we have challenge.
Victim is not coming to your
No,
place.
ma'am. We become the
But
origin.
the fact is that if the victim appears in the case in another state
Yes, ma'am. He appears there.
and he is convicted, so that becomes important for you, isn't it?
Yes, ma'am.
So therefore, how do you get the status of such conviction of the?
And the IO informs us later. IO informs us, and we also request the IO to let that victim appear in our case also, because the trial is still pending, remains pending.
But for the same thing, for the same one victim, he will be tried at two places.
और एफआईआर की लॉन्च नहीं होती।
So for one victim, he will not be tried at two places, because that's a distinct offence. It is coming in your FIR, but if he is already convicted with respect to one victim, so there is no point that you will ask him to be here also. It should be sufficient that his order of conviction is placed before you, that he has been convicted with regard to this victim. That should not be sufficient.
But ma'am, that number might or might not be involved in number of complaints, not just that victim.
But I don't think that for one victim he will be tried at two places.
No, ma'am. But if multiple complaints are there against one number, ma'am, against which the accused has been arrested, in that case we might need clarity. Because the police has arrested the accused on the basis of location, and that number is involved in n number of complaints.
One last question, madam. If there are n number of complaints, so technically there are n number of FIRs. Technically, right? And if in connection with n number of FIRs, the accused is tried at different locations, and he is convicted or acquitted or whatever, then under such circumstances, that particular victim who has participated in the trial in connection with the same complaint, there is no question of trying him here, except that the conviction has been secured or not. So it requires better coordination amongst the state. that it should be reported. When you report it in the portal, you see, you report it in the portal complaint. Once he is convicted, you report it in the portal only convicted. Isn't it? It can be simultaneously done. Because that particular item in the portal is showing the victim. The moment he is convicted, it can also reflect that he has been convicted in whatever case it is. And all the orders, I think all over India, is being uploaded on the portal.
Your Lordship, I would like to clear a little. What happened, a particular ID has been used for committing an offence. But what happens, that date and time and places keep on changing in cyber. So for the reason, if there is a victim and a case has been instituted at one instance, but the same ID has been also used in the different time and place. So for the reason a different FIR they have instituted for it.
That is what I am saying. Every victim constitutes a separate FIR. भाई एक तलवार से 10 लोगों को 10 बार अलग अलग टाइम से मारेंगे तो 10 FIR होगा कि नहीं होगा?
Exactly. And what your lordship happened? Suppose a person has cheated A and then B. There is a chain. So for the reason what happened, A has instituted an FIR and B has instituted an FIR. But what happens is the chain is establishing from A and B. So in A case, B becomes a vital witness, and in B also the A becomes a vital witness. In order to establish
not
the chain.
necessarily. Not necessarily. The reason being that if A has been cheated, B has also been cheated. A has been cheated by using the same device. B is also cheated by using the same device, but there is no link between A and B. Otherwise, except the device used. It is something like एक पिस्टल से 10 लोगों को मारेंगे अलग अलग टाइम पर तो 10 FIR होगा कि नहीं होगा? कि एक ही FIR होगा? कि एक पिस्टल से मारे हैं? Let us see it in the real time. Isn't it? अगर मान लीजिए एक डकैती में 10 सामान चोरी हो जाता है 1 FIR, राइट? अगर 4 अलग अलग लोकेशन में डकैती होती है तो 4 अलग अलग FIR होगा कि नहीं? उसी तरह से एक डिवाइस यूज करके अगर आप 4 अलग अलग विक्टिम को डिफरेंट पॉइंट ऑफ टाइम में आप उसका पैसा ले रहे हैं उसके अकाउंट से, इट विल बी वन ऑफेंस, इट विल बी सेपरेट ऑफेंसेस. There is no such. You see that the crime is not linked to the device. The crime is linked to the victim. मेरे पास डिवाइस है, हम यूज नहीं किए तो उसका कुछ और ऑफेंस हो सकता है. मेरे पास डिवाइस है, हम यूज किए सक्सेसफुल नहीं हुए तो कुछ अटेम्प्ट का ऑफेंस हो सकता है. मेरे पास डिवाइस है लेकिन हम अलग अलग टाइम पे 10 अलग अलग विक्टिम का पैसा चुराए उसके बैंक अकाउंट से तो 10 अलग अलग FIR होगा ना. Then how will you say that he does not have a criminal antecedent? ऐसा रिपोर्ट आप लोग का नहीं आना चाहिए. Should not come. And Madam T, I do not know, you must be having your own meetings about this cyber crime from time to time. Try and figure out if एक victim का कोई conviction हो जाता है, तो can it be reflected in the portal that he has been convicted?
In the remarks column, it can be added in the national cyber crime report.
It can be
I
added.
can add it as a remark that the person has been
Convicted. And once he is convicted in that, then under such circumstances, why should he be proceeded in another case for that particular victim? Isn't it?
No, but as Sir said, it is done using the same bank account at different time and different things. For example, if one bank account is used to transfer 30 lakhs of one victim and 40 lakhs of another victim, then it constitutes 2 offences. If he is convicted in one case, then he has to be convicted in another.
No, he has to be convicted, but there has to be a conviction with regard to the second victim also. Right? There has to be a conviction with regard to the second victim also. And if a person is accused of having 5 victims and in 5 different locations he has been convicted, then your case should close down. Because for those 5 victims, he cannot be convicted again. Certainly, he cannot be convicted again. And suppose in connection with all the 5 victims, he has been convicted at your place, he cannot be convicted separately for each victim in other states. Isn't it? This is what I was just wondering, how is it happening? Anyways, please try to find out and have better investigation. And please, there is a nodal point from where you can get the antecedent in the capital. All the antecedents should come from the capital, because a person may not be an accused in the same police station. You are getting the antecedent from the district. That may not be sufficient. He may shift from one district to another to commit the crime. Phone लेके दूसरा district में. Antecedent report आपके centralized body से आना चाहिए, at least for the state.
यहाँ पे जो हम लोग को रिपोर्ट डिफाइन करेंगे, जो कंप्लेंट जो हो रहा है साइबर में, उसको क्रिमिनल एंटीसीडेंट
उसको नहीं ट्रीट करते।
क्रिमिनल एंटीसीडेंट
यस मैडम।
ये क्रिमिनल एंटीसीडेंट किसको ट्रीट कर रहे हैं? जो आईसीटीएस पोर्टल में, स्टेट गवर्नमेंट का पोर्टल है और नेशनल गवर्नमेंट का जो पोर्टल है, उसमें जो क्राइम क्रिमिनल केस का लिखा हुआ है, उसी को क्रिमिनल एंटीसीडेंट का रिपोर्ट दे रहे हैं। लेकिन कॉमन जो हमारा कंप्लेन होता है साइबर क्राइम,
उसको ट्रीट नहीं करते।
कंप्लेन होने के बाद साना होता है, साना के बाद एफआईआर होता है, एफआईआर होता है तो उसको क्रिमिनल एंटीसीडेंट का रिपोर्ट देते हैं। ये कॉमनली इनके डिस्ट्रिक्ट में होता है।
You do not treat the complaint by itself as an antecedent.
No, ma'am. Whatever is reported on the National Cybercrime Reporting Portal, that is specifically has to be mentioned as a separate category of criminal antecedent in this case.
Yes, सुनिए।
और एक नाम ICS
कंप्लेंट लिखते हैं, उसको वर्ड जो लिखते हैं हमारे जो डायरी में आ रहे हैं, कंप्लेंट इनके अगेंस्ट में इतना कंप्लेंट लॉन्च है।
तो बोल रहे हैं कि हर एक कंप्लेंट is to be treated as a separate complaint.
नो, ऐसा नहीं।
Antecedent.
उसको एंटीसीडेंट माना जा सकता है, लेकिन उसको एफआईआर नहीं मानते। ये एक्चुअली डिफरेंट डिस्ट्रिक्ट है हमारे। ये रांची की है, रांची के ऑफिसर इंचार्ज है। रांची में ये कॉम्प्लिकेशन नहीं हो रहा, देवघर, जामताड़ा, गिरिडीह के साथ ये कॉम्प्लिकेशन। हमारे साथ डिफरेंट डिस्ट्रिक्ट में मोड ऑफ क्राइम अलग टाइप का है, लेकिन उनके यहाँ से ये चीज नहीं। जबकि मैंने कैब में लिखा भी उसको कि उसको वेरीफाई कीजिए, उसको एक्नॉलेजमेंट पे एफआईआर हुआ कि नहीं हुआ।
On that acknowledgement, do you view that acknowledgement as an FIR?
as a complaint. And if FIR has been registered in that state, ma'am, separately on the basis of that complaint, that is reflected on the portal. Then we have to include that part as a.
Then you have to include. It is reflected in the portal.
Yes, ma'am.
When you give the antecedent report, do you show it that it has been reflected as a?
Yes, ma'am. There is an FIR number and we quote it. And that in this state.
इनका कहना है कि अगर दूसरे स्टेट में रिपोर्ट हुआ है वो एज एन FIR and additionally it is reflecting in the portal as an acknowledgement, then only it will be treated as an antecedent. लेकिन अभी तक कोई भी मेरे पास ऐसा कोई antecedent report नहीं आया which is saying that one case has been arising out of this victim is reflecting as an FIR in another state. Is it visible in the portal?
It is visible in the portal. If the acknowledgement number has been converted into FIR by that state, it is visible on the portal. The FIR number and it is downloadable also. The FIR can be downloaded.
Then who will give this information? The antecedent report will come accordingly. लेकिन आज तक एक भी ऐसा कोई नहीं आया मेरे पास।
चार्ट में आता है जो पोर्टल को प्रिंटेड कॉपी लगाते हैं, क्रिमिनल एंटीसीडेंट
आपका जो एंटीसीडेंट रिपोर्ट मंगाते हैं ना उसमें लिख के दीजिए, हमको चार्ट नहीं चाहिए आपका। सेपरेट एंटीसीडेंट रिपोर्ट इज बीइंग कॉल्ड फॉर, यू पुट इट इन दैट चार्ट।
वो करते क्या है कि वो एक आईसीटीएस पोर्टल का डाउनलोडेड कॉपी प्रिंट करते हैं या नेशनल पोर्टल का डाउनलोडेड कॉपी प्रिंट करते हैं, उसके साथ अपना क्रिमिनल एंटीसीडेंट
उसमें खाली लिखते हैं कि कंप्लेंट लॉज्ड, लेकिन उसमें नहीं लिखते हैं कि एफआईआर हैज बीन इंस्टीट्यूटेड। मैडम इज सेइंग दैट एफआईआर इफ इंस्टीट्यूटेड इज आल्सो रिफ्लेक्टिंग इन द पोर्टल, बट दैट दे आर नॉट राइटिंग दैट एफआईआर हैज बीन इंस्टीट्यूटेड बाय वर्च्यू ऑफ दिस कंप्लेंट। इन नन ऑफ द केसेस आई हैव सीन दैट। किसी का बड़ा अमाउंट होगा तो एफआईआर तो जरूर करेगा। हम नहीं मान सकते हैं कि कोई 30 लाख रुपए किसी का चला जाएगा और एफआईआर नहीं इंस्टीट्यूट होगा। आई डोंट एग्री टू दिस। तो एंटीसीडेंट भाई थोड़ा इसको देखिए कि एंटीसीडेंट रिपोर्ट सही से आना चाहिए। आपका लिखेंगे ना इसके अलावा कोई केस इंस्टीट्यूट नहीं है, हम तो वही मानेंगे, इसके अलावा कोई केस इंस्टीट्यूट नहीं। जैसे एक किसी का कहाँ से आ रहा था एक साइबर क्राइम में जिसमें आप बोल रहे थे कि वो बांग्लादेश और क्या क्या इन्वॉल्व है, उसमें इट वाज देयर दैट केस इज रजिस्टर्ड एट छत्तीसगढ़ या कहीं पर था। हाँ उसमें था वो।
एक्चुअली कहीं इन्वेस्टिगेशन हो रहा है बहुत अच्छा है, जैसे रांची का इन्वेस्टिगेशन अच्छा हो रहा है जहाँ सी मैडम, और वही अगर दूसरी जगह का इन्वेस्टिगेशन हो रहा है तो हम खुद अब मैंने रिलाई करते हैं उसको मैंने अनऑफिशियली कि इन्वेस्टिगेशन बहुत
और केस डायरी के साथ इनको एनक्लोजर्स भेजा करिए। इनका ये कहना है कि एनक्लोजर्स आप नहीं भेजते, बार बार ये बोलते हैं लेकिन फिर भी नहीं भेजते। सो एनक्लोजर्स आर इम्पोर्टेंट। और वी आर क्लबिंग ऑल द केसेस अराइजिंग आउट ऑफ द सेम एफआईआर। वन सेट ऑफ केस डायरी के अलावा आपको हर एक केस में केस डायरी भेजने की जरूरत नहीं है। एंड आस्किंग टू रिटेन इट टिल ऑल द को-एक्यूज्ड पर्सन्स का बेल कंसिडर हो जाए चाहे। द ट्रायल इज ऑन, जो चार्जशीट हो जाता है, इन्वेस्टिगेशन इज ऑन, तो क्या करते हैं उसमें?
Ma'am, we keep on analyzing the money trail. Ma'am, analyzing the money trail has become a very big challenge. We keep on tracing the money trail.
And the accused is not put to trial till you are finished with the investigation.
No, ma'am. Once the charge sheet, the accused is arrested and charge sheet is submitted within 90 days, the trial is continues.
And suppose you get more victims thereafter?
And we give supplementary case charges in the court for adding the evidence.
ठीक है।
और एक और है कॉमन जो होता है ना, विक्टिम 2000, 4000, 5000 चीट किया गया दिल्ली से, उसको ट्रायल करने के लिए अगर जामताड़ा बुलाया जाए तो
नहीं बुलाया जाएगा,
जामताड़ा से जाता
आपको नहीं बुलाया जाएगा। इट कैन बी डन ऑनलाइन।
वो ऑनलाइन भी आना नहीं चाहता है ना, दिन भर काम छोड़ के ऑनलाइन 2000, 4000 के लिए तो कॉमन सा बात होता है कि एक हम लोग को भी अगर कहा जाए कि मेन रोड में वो चीज 100 रुपए का जाएगा, कौन मेन रोड जाएगा? वो तो दिल्ली से 2000, 4000 छोटे अमाउंट वाले होते हैं ना, तो वो हमेशा नेगलिजेंट रहता है उनका कोर्ट प्रोसीजर। और एक बार कॉल हो जाए तो दोबारा तो फिर तो कॉल उठाना बंद कर देंगे डर से, दोबारा फिर तो नहीं आ रहा है। झारखंड का कॉल आ रहा है, हमको लगता है पीपी साहब भी जब कॉल करते होंगे तो कई बार उठता होगा कि नहीं उठता होगा। हम लोग कई विक्टिम को यहाँ कॉल करते, कभी कभी कोर्ट जो डायरेक्शन देता है कि विक्टिम को नोटिस दीजिए, हम लोग कॉल 10 बार में इंटरटेन होता है। तो ये भी एक है कि छोटा अमाउंट के लिए सब विक्टिम्स जो होता है थोड़ा एक्टिव नहीं होते, सिंसियर नहीं होते, गया सो गया दोबारा फिर होता है, इस तरह का भी डर होता है।
The second thing is that should be out of the court compromise is a major issue because some money
इशू नहीं, ठीक है, पैसा मिल गया,
पैसा मिल गया।
ना बड़ा अमाउंट होता है।
The thing is that they enter into any kind of huge amount है। Recently I have seen a case where there was a cyber fraud of 10 lakh rupees and the victim easily got 750 lakhs and he was okay with that.
कॉम्प्रोमाइज करके क्या बोलते हैं कि हमने कॉम्प्रोमाइज कर लिया?
Exactly, they come because section 77 is a compoundable section.
तो कंपाउंडेबल का मतलब क्या होता है? That you admit your guilt, isn't it?
Exactly.
Compoundable is you admit your guilt.
That will become a criminal antecedent.
That will become a criminal antecedent.
Criminal antecedent.
तो फिर कहाँ है आप? बस सोच ही नहीं रहे हैं बस। कंपाउंड कर लिया तो क्रिमिनल एंटीसीडेंट बन ही गया, फिर क्या? Compounding means admission.
Admission, sir. That's an admission of the guilt. So for the reason,
It is only the punishment which is modified or taken care of. Since the guy has got the money, he doesn't have any surviving demands. Anyways,
your Lordship, with permission, just would like to bring the in the knowledge of this court that ADC2 is the designated court for getting trial of ERT cases. Along with this court is special court for SC/ST cases also, drug cosmetic cases also, along with the general system trials and the NDPS cases also.
देखिए, I'll tell you one thing, that if you are able to produce the witnesses, there can be no reason that the evidence will not be recorded.
Lordship, we don't turn the witnesses, we get it recorded at any cost. Even today we
आप बस अपना काम करिए, आप अपना एविडेंस प्रोड्यूस करिए। मेरा फर्स्ट हाफ में बेल है, सेकंड हाफ में फर्स्ट अपील है, तो ये सब जगह चल रहा है। वी हैव dearth of judges also, there are so much of crime, अब everybody has to handle it, लेकिन आप अपना विटनेस प्रोडक्शन में आप बिल्कुल भी पीछे मत रहिए। एंड इन स्पाइट ऑफ दैट यू सी, हम लोगों की नज़र बहुत तेज़ है डिस्ट्रिक्ट जुडिशरी पर। कोई भी कोर्ट एविडेंस रिकॉर्ड करने से मना नहीं कर सकता, और एक बार अगर एविडेंस हो गया तो ही जस्ट कांट कीप ऑन पोस्टपोनिंग कि आर्गुमेंट चल रहा है 6 महीने से।
No, Your Lordship, this is not. The PO,
This will never happen.
No, this is not.
And you also ask your APP to prepare short synopsis for the court. वो synopsis बनने से कोर्ट को easy होता है। But synopsis जो भी बनेगा on the basis of the records only.
Exactly.
Right?
We do provide even at the 313 stage or at the argument stage or even at the starting for the bail stage, we do provide the important synopsis along with the relevant paras, and whatever is required we do provide, and we do all the assistance what is required by the prosecution to assist the law. We do all
That's
that.
right. सबके अपने अपने प्रेशर्स हैं काम के, बहुत ज़्यादा नहीं बोल पाएंगे, लेकिन यू डू योर बिट. ऐसा कभी होता है कि आपका विटनेस गया और गवाही नहीं हुई? ऐसा कभी होता है?
At times, not general case no, but when suppose if there is a convenience,
That is a separate
that
thing.
is a separate thing. Otherwise, no. That
नहीं
witness
होता है
has
ना?
to be examined. The witness comes on, it will be examined.
ऐसा कभी होता है कि एपीपी ने विटनेस वापस भेज दिया?
No, that doesn't happen because at the time we know that the victim is coming for fast stage. What happens at times? At first, to your worship, at certain stages we get the evidence recorded, but at times we don't find the certified copy of the bank transactions. So we have two options: either to get it by the victim itself, if he says that he has got in his
You can ask the
possession.
bank also provide.
Your worship.
बैंक तो हर एक ब्रांच में मिल जाएगा, आपको क्या दिक्कत?
But the thing is that they will provide either to the IU or they will provide to the victim. So for the reason, because if you will write to the bank, they will take a lot of time.
No, you have to ask your IU to go there.
Exactly. Your lordship, when the victim has if the victim has came and deposed, and later on when the IU examining, we does not find that certified copy is there, we ask the IU to bring it, and later on under the Bankers Evidence Act, under Section 3 of the Bankers Act, we get it exhibited as a public document.
That's right. It's very simple. Banking documents can be exhibited. Very simple.
Public
There is no
document. So for the
problem.
reason we get it.
And they certify also. They give a certificate that it is
Is it true
downloaded
copy?
from the system. So that is as per Banker Books Evidence Act that can be exhibited.
सर मैम जैसे कि डेटा मंगाया
हम्म.
तो सोशल द्वारा कितनी गवाही कराई गई एक साल
हम्म.
वो मेरे पास
अच्छा अच्छा.
एक डाटा का नोटिस
इसमें दिखा है कि प्रोसिक्यूशन कितना गवाही करा चुका है, कितना इसलिए गवाही वापस नहीं होता है, इसका ये एक तरह से प्रूफ है कि पिछले साल लगभग
नहीं, हम
1,57,000
आपको ऐसा नहीं बोल रहे हैं. हम ऐसा बोल रहे हैं. You see, I am not accusing you for anything. एक तो एंटीसीडेंट के बारे में समझना है हमको, इसीलिए बुलाया है कि वो जो आप FIR करते हैं, that is only one case or it is a multiple cases put in one FIR. उसमें से भी जो ऐसे विक्टिम है, तो that may not constitute a separate FIR. But if a separate FIR has been instituted, then that will constitute a separate criminal antecedent. Otherwise, it is not a criminal antecedent, as she told us. And you are, I have no doubt about it. You must be doing it. ऐसे थोड़ी आप कर रहे हैं, ऐसा नहीं सोचते हम लोग. We assume, and at least I always have faith that whatever you are doing is absolutely correct. There is no reason to disbelieve what you say, and there is no reason to doubt that you are not doing the right thing. But only to understand it better, that how to see the criminal antecedent and why in certain cases where the state is the victim, you are not following up the person who has actually paid the amount and claims that I have already paid them. Then you have to tell him, no, this payment is a fraud. Right? बस इतना ही थोड़ा ध्यान देने की जरूरत है. एक आध बार तो फ्रॉड हमारे साथ भी हो चुका है, तो थोड़ा आइडिया है कि क्या क्या. एक बार रांची म्युनिसिपल कॉर्पोरेशन में पेमेंट किए, पता चला किसी और अकाउंट में चला, मतलब ऑनलाइन पेमेंट.
There are number of cases, ma'am, of this point. The
Are
other
you
reason
sure?
Yes, exactly.
उसका आप क्या करते हैं? कुछ नहीं करते.
I think no, Your Worship.
No, I got my FIR was also there of September 2024,
Yes.
and they have recovered my money on the but
Even
no,
I have
no
my
prosecution, but
no prosecution. This is what I'm saying. पैसा मेरे पास आ गया वापस.
come and I'm called.
लेकिन this is not
I'm
fair
here.
ना.
I'm here.
आप FIR नहीं करते हैं. हमसे
FIR
बोलेंगे तो हम गवाही करेंगे.
FIR तो हमारा हो गया मैम.
What do you mean?
But I'm not being called.
Yes.
I'm not being called.
FIR हो गया, पैसा नहीं गया. आपको कुछ.
Yeah, but I'm interested in the prosecution
Yes.
also. They should be punished. It's a law.
They should be
Not to see, but
कि कोई भी एक ऑनलाइन पोर्टल करके आप तरह तरह का पेमेंट ले लीजिए. RMC का पेमेंट ले लीजिए, ये वाला मोटर व्हीकल का होल्डिंग टैक्स ले
Holding
लीजिए.
tax payment.
Right.
The matter is
गाड़ी का
under
चलान
investigation.
में भी आने लगे.
हाँ?
गाड़ी का
हाँ, इलेक्ट्रिसिटी बिल का पेमेंट ले लीजिए.
तो अपना भी तरीका खोजते रहता है अलग अलग क्या.
तो नहीं, लेकिन जिन्होंने FIR that like Mr. Manish is saying that he has lost an FIR, लेकिन कुछ नहीं है, कुछ हो ही नहीं रहा है.
Forwarded to Sharminder.
And what is it?
1,69,000. The next day, the Cyber Thana sent an email. The money was recovered after 2-3 days. But after that, whenever they have called me for investigation, I have gone. I have not been caught for as a witness.
Exactly.
And this is 20 months.
This matter is
117 of 2020.
cyber crime PS.
I'm giving the number.
Cyber crime PS.
हमको दे दीजिएगा.
अभी इन्हीं को दे दीजिए.
एक बार ऐसा
लेकिन दिस इज नॉट द ओनली इंसिडेंट. हमारे पास भी मेरे ख्याल से FIR तो हम लोगों ने नहीं किया था, लेकिन
एक बार हमारे साथ हुआ कि एक रोजर पे करके एक ई-वॉलेट चल रहा था. तो हमारे पास जो केसेस आते हैं, देखिए कि जितने साइबर क्रिमिनल्स उस रोजर पे को ही ज़्यादा प्रीफरेंस कर रहे हैं मनी ट्रांजैक्शन के लिए. तो मैंने नेहा से डिस्कशन किया, तो ये बोले कि नहीं सर, मेरे साथ भी ऐसा ही हो रहा है कि हम भी देख रहे हैं कि अभी 2-3 महीने से जितना साइबर क्रिमिनल्स है वो रोजर पे को ही चॉइस में ले रहे हैं मनी ट्रांजैक्शन करने के लिए. तो हम लोग बोले कि हम लोग को क्या करना चाहिए. तो ये बोले कि आप एक लेटर बनाइए, हम भी अपने स्तर से फॉरवर्ड करते हैं. एक हफ्ता गुजरा, नेशनल न्यूज चैनल पर देखे कि उस रेजर पे को बैन कर दिया गया. तो एक्स्ट्रा इसके अलावा भी करते रहते हैं, लेकिन एक तो मैकेनिज्म हम लोग का बना हुआ है.
देखिए ये जो ऑनलाइन, अब मान लीजिए गैस सिलेंडर का ट्रांसफर है, ये जो गैस का पेमेंट करते हैं हम लोग, जो भी पाइपलाइन से आता है, अब इस पे अगर फ्रॉड होने लगेगा तो कितना मुश्किल.
वो भी अपना खोजते रहते हैं मेथड, नया मेथड खोजते रहते हैं हमेशा. वहाँ उनके लिए भी रिसर्च हुई है.
वो प्रोफेशनल हैं, आप भी प्रोफेशनल बनिए, उनसे 4 कदम आगे रखिए. चलिए ओके. हाँ,
हम लोग इससे आपस में डिस्कस करके हम लोग एक इनसे डायरेक्शन जो है.
हाँ, ये थोड़ा सा देख लीजिए भाई कैसे आप लोग करते हैं और क्रिमिनल एंटीसीडेंट कैसे देना है, और ये जो छोटा छोटा FIR जो लॉज होता है इसका आप क्या कर रहे हैं.
एवरेज हाई कोर्ट में 2 से 3 एडवोकेट के साथ साइबर क्रिमिनल
पर डे,
क्योंकि 2 से 3 लाइक वो उसमें से मैक्सिमम हमको कॉल करते हैं कि सिलेंडर देखो ऐसे आप क्या करें इमीडिएटली. तो मेरा भी हेल्प नंबर चलता है.
आप एक हेल्प डेस्क खुलवा दीजिए आप.
हम लोग कराए थे साइबर अवेयरनेस का प्रोग्राम कराए थे पुराने कोर्ट, और अभी लोग हैं लोग का हम एक साइबर अवेयरनेस का फिर कर रहे हैं. लोग क्या डिस्कस करते हैं.
चलिए
From the daily published under heading for final disposal, item 2, WPL 7272 of 2005.
submissions. Yes.
What was the industrial tribunal? I'm not in the challenge here. Where, my lord, the learned industrial tribunal had found our domestic inquiry to be fair and proper. And after finding our domestic inquiry to be fair and proper, they have proceeded to set aside the order of termination and order reinstatement. That is, my submission would be that this award is totally perverse. I'm not doubting or questioning the rejection of the industrial tribunal to look into the evidence again. But there are categorical judgments that until there is my lord, the tribunal will be very slow to interfere. If two views are possible, they will go with one view, etc. Here, my lord, the workman had been accused of threatening a management personnel with a pistol. So, and we had led evidence to that effect during the domestic inquiry, which was found to be fair and proper. Later, the learned industrial tribunal read that the evidence was bad. If your lordship has the award, it will be 122.
The learned counsel for the petitioner has submitted that the inquiry was found fair and proper, with which the petitioner has no grievance. However, the learned court has proceeded further to examine the materials to set aside the order of dismissal and directed reinstatement with full packages. He submits that the order passed by the learned industrial tribunal is perverse in the matter of appreciation of evidence, considering the scope of interference once the inquiry is found to be fair and proper.
Well, and here it's not full back, it is 25%.
Okay, 25% back, which is कौन सा judgment है? He has relied
But
on
here,
the
that's
judgment.
first, before going to the judgment, Your Lordship, some
I'll
facts.
come to that. I'm just recording that.
But
One judgment is a clear judgment on this.
there are number of judgments.
Number of judgments. Anyways, the learned counsel submits that the workman was accused of threatening the management with a pistol. चलिए अब बताइए.
My lord, here the words start from page 122.
Yes.
My lord, I invite your lordship straight away to page 124, 123 bottom.
124.
123 at the bottom starts the paragraph.
Okay, 123. Yes.
Management, on the contrary, after filing WS come rejoinder, have denied all the claims and allegations which the concerned workman asserted in his written statement. They submitted that during sea shift duty of 18/6/94 at 1:30 am of 19/6/94, the concerned workman came to the Sigdolia colliery and after meeting Mr. R.C. Singh, assistant colliery manager of that colliery who at that relevant time was found standing on the surface at 15 feet top, threatened him to kill, taking a revolver in his hand. He also made query to him as to why he was not granting leave to the employees. However, said R.C. Singh, assistant colliery manager, somehow got his escape from him and came to the security department and informed the matter to them. He informed the security authorities. When the officials of the security department reached the spot, the concerned workman fled away from the place of offence. As the offence committed by the etc. Your Lordship, then he is denying these allegations. Now, Your Lordship, after that, Your Lordship, the next page, page 125, the findings starts here. It transfers from the record that before taking up hearing of this case on merit, it was taken into consideration whether domestic inquiry held against the concerned workman was fair, proper, and in accordance with the principles of natural justice. It is seen that the said issue on preliminary point was disposed of in favor of the management by order number 94 dated 15/6/2004. 15/6/2004. Now the point for consideration is whether management have been able to substantiate the charge brought against the concerned workman, and if so, whether the concerned workman is entitled to get any relief under section 11A. My lord, then next page, Your Lordship, page 127, it is the specific allegation again of the management that at 19/6/94, I am not repeating that.
Yes, that's true.
Then again it goes on in the middle on receiving the said news and the security. It is seen that over the incident, no
yes.
FIR was lodged.
That's right. It
Again,
is seen
the-
that over the said incident, no
No
FIR was lodged. Read it further. Considering
Considering
the
report, I have failed to find out any complaint lodged by the complainant, Mr. R.C. Singh, over the incident in question. Learned advocate for the management has failed to satisfy this tribunal in course of hearing if any written complaint was submitted by the complainant, Mr. R.C. Singh, to the management over the incident in question. Therefore, it is seen that without lodging any FIR and also in the absence of any written complaint, disciplinary authority issued a charge sheet against the concerned workman. The charge sheet marked at exhibit M1 also does not speak if any written complaint was lodged by the complainant or not. Against the charge sheet, concerned workman submitted his reply which during hearing was exhibited as exhibit M2. In reply, the concerned workman denied all the charges brought against him and allegedly took the plea that at the time of relevant incident he was not at all present on the spot on the ground. At that time he was admitted in the nursing home of Mr. MP Saha nursing home, Chatabad, Malkera, Dhanbad. Now after that the management witnesses start your
proceed, read it.
Then after that,
As the reply of the charge sheet.
then okay, I think. as the reply of the charge sheet given by the concerned workman was not satisfactory, the disciplinary authority appointed Mr. M.M. Haq, Deputy Manager Personnel, as inquiry officer. During hearing of the inquiry proceeding, inquiry officer examined Mr. R.C. Singh, Mr. N.K. Gupta, Assistant Manager, and Ajay Kumar, 3 witnesses.
R.C. Singh is the person who complained.
Complainant, yes. He was the complainant. And then, from the statement of Mr. R.C. Singh, it is transpired that on 19/6/94 at about 1:30 am, while he was on the 15th pit top, the concerned workman, that is Dharam Singh, an employee of Project Villa Town, came to him with a revolver in his right hand. And thereafter, putting the revolver on his chest, asked him why he was not granting leave. Shri Singh resisted. When Shri Singh resisted, he saw another person standing about 20 feet away who was covered with a shawl. On moving further ahead, he found another person standing at 11 feet. Thereafter, he came to the security office and informed Mr. Ajay Kumar, security officer, about the incident in question. This witness submitted that at the time of the incident in question, N.K. Gupta and Durga Mahato were present on the spot, and they witnessed the incident in question. No evidence is forthcoming whether the leave application of the concerned workman was with the complainant for disposal or not. On the contrary, this witness during cross-examination admitted that the concerned workman never approached previously regarding his leave. It is also not evident if Mr. R.C. Singh was the controlling authority of the concerned workman and was in charge of sanctioning any leave to the concerned workman. The charge sheet while speaks that R.C. Singh was charged by the concerned workman why he was not granting leave to the employees. The statement of R.C. Singh on the contrary appears to be different on that point. During hearing, management have failed to examine Durga Mahato, who was an eyewitness of the incident in question. Considering the statement of N.K. Gupta, he was also an eyewitness. It transpired that on the relevant date and time he was on leave. However, he was present on the spot with a view to line up job of his section and went to 15 feet top between 1:50 to 1:30 am. This witness disclosed that when he was talking with the miners, he noticed the concerned workman to talk with Mr. R.C. Singh. Sometime after
Who is that concerned workman? What is his name?
Dharam Singh.
Dharam Singh. He was holding the pistol.
But
Oh.
this witness disclosed that when he was talking with the miners, he noticed the concerned workman to talk with R.C. Singh. Sometime after, the said person came to him and shook his hand. This is important, and asked him, "Sahab, aap mere ghar khana khane chaliye." This witness disclosed that the concerned workman was at that time in drunken state. He helped him to move forward towards land given from pit top. At that time, he found a pistol with the concerned workman. He presumed the pistol as toy pistol. This witness did not disclose in which part of the body of the concerned workman he found the pistol. This is a peculiar logic. The pistol would be in the hand like this. When this witness disclosed that the delinquent shook hands with him, in that case it was not possible on his part to possess the alleged pistol in his hand because of the fact that it is not possible on the part of the person to shake hands with a pistol in his hand. My lord, here I have to submit a pistol can be held in one hand, it's not a cannon he is holding. So, from the statement of Ajay Kumar, security officer, it transpires that on 19/6/94 at about 1:30 am, Mr. R.C. Singh came to his control room from the Koldri side and informed that one person came to him on the pit top with his mouth covered, and thereafter the said person placed revolver on his chest and asked him why he was not granting leave. Said R.C. Singh further disclosed that somehow after letting him escape from his hand, he came there with a view to inform the incident in question. After receiving the said news, he rushed to the spot but did not find the delinquent, that is the concerned workman. During cross-examination, N.K. Gupta firmly disclosed that if he did not find the concerned workman to place revolver on the chest of R.C. Singh, he only found him to talk with R.C. Singh and a pistol in his hand. He further admitted that while the concerned workman was talking with R.C. Singh, his face was not covered with anything. Therefore, if the cross-examination of N.K. Gupta is taken into consideration, it will expose clearly that he made an exaggerated statement to the security officer Ajay Kumar after coming to the control room. It is also curious to note that though R.C. Singh by name and face was acquainted with the concerned workman, instead of disclosing his name, disclosed to the security officer that one person at the pit top number 15 on 19/6/94 at 1:30 am came to him and placed revolver on his chest, covered his mouth and asked him why he was not granting leave. This witness I have already discussed did not state anything whether he was controlling leave sanctioning authority of the concerned workman, and any such leave application was pending to him. Therefore, it is not at all clear for granting of whose leave the concerned workman intended to create pressure on him. If the evidence of N.K. Gupta is taken into consideration, it will expose clearly that the concerned workman was in drunken state at the relevant time, but I do not find its corroboration from the statement of R.C. Singh. My lord, sometimes a person is drunk, everybody can't make out at night, it's 1:30 a.m. It is further seen that the concerned workman, that is the delinquent, had a good relationship with Mr. N.K. Gupta. This is important that, my lord, one of the witnesses who was in against the workman, N.K. Gupta. It is further seen that the concerned workman, the delinquent, had a good relation with N.K. Gupta, and had that not been so, he would not request him for having meal with him at his house. Not only Mr. N.K. Gupta, Durga Mahato were present on the spot, there were also many other minors and tremors were present. It is curious to note that the management did not consider necessary to examine Durga Mahato or other tremors and minors loaders who were present on the spot. It is also very curious to note that R.C. Singh reported the incident in question to the management on the basis of the charge sheet issued against the concerned workman. Therefore, the role of R.C. Singh cannot be considered as independent. Knowing fully well of this fact, the management engaged R.C. Singh as presenting officer to present the case on behalf of the management. My lord, here I would submit that this is immaterial. There are a number of judgments of various high courts that presenting officer is presenting the case of the management. He is not required to be a totally independent person. The inquiry officer, yes. I have carefully considered all the statements of witnesses, and after careful consideration of all the material evidence on record, I find no hesitation to draw conclusion that the statement of one witness varies from the statement of other witnesses in a very ugly manner. But there is no variation. Apart from written detail that it was covered with a shawl, after some time the shawl is removed. Apart from these minor, there is nothing. Considering statements all the witnesses, there is sufficient reason to believe that R.C. Singh was not in good relation with the concerned workman. Here, Your Lordship, I will, with Your Lordship's permission, show one document. My Lord, when the charge sheet was submitted, the original, and he replied to the charge sheet, which is at page 55. Page 55. Not sure to the charge sheet.
Let us see the charge sheet first.
Yes. That is at page 54.
Can you read it once?
Right.
Can you read it once?
It has been reported that on 18/6/94 at about 1:30 a.m. in sea shift, early hours of 19/6/94, you went to Sijua Quarry 15, picked up with a revolver in your hand and threatened Shri R.C. Singh, assistant manager, Sijua Quarry, to kill him. You also asked as why he was not granting leave to the employees. Shri R.C. Singh somehow managed to escape. He immediately informed the security department. Before the security personnel could reach the quarry premises, you had fled away. The above act on your part amounts to not only threatening a superior officer but also to serious disorderly behavior.
This is without any written complaint.
No, this is without any. Because this is serious enough to.
Is it not? Written complaint is not required.
Not mandatory, Your Honor. At least the written complaint is not on record.
Because a written complaint, itself would show as to whether there is further improvement, there is further diversion from whatever has been stated in the complaint.
My lord, that is there, but the person with the
Anyways.
revolver may not be often in a position, some kind of a managerial personnel. It's not a Now, this is the reply to the charge.
Yes.
My lord, should I place the full
Page 55, you just read the
The
relevant
bottom
portion.
few lines, Your Lordship.
Yes.
55, the last few lines, last bit. In the last paragraph, I'll read in full. Your Lordship. That in the charge sheet served on me, it has been alleged that in the early hours of 96-94, I went to secure in shift duty with the revolver and threatened the assistant manager, Shri R.C. Singh, on duty for not granting leave to the employees. Such an allegation has come to me as a bolt from the blue as it is without any foundation. Now, next line the report. I have never worked under him and nor had any quarrel with him, and so it is a treat surprise to me as to why he should raise such a complaint against me. Against this, the London Industry Tribunal, the last line I read, he seemed there, R.C. Singh seems to have page 131. I repeat it again. considering statement of all the witness, there is sufficient reason to believe that R.C. Singh was not in good relation with the concerned workman. Page 131 is the specific finding, which is totally perverse. Totally perverse finding. And for which way or that way his intention was to take revenge against him. The workman is saying, I have no quarrel with him, I have never worked under him, and here the learned
This you have read in 131.
Page 131, I am rereading it.
I'll just mark it, that is
My lord. Around 12-13 lines from the board.
okay. That is the way his intention was to take revenge.
Yeah, considering statement all the witness, there is sufficient reason to believe that R.C. Singh was not in good relation with the concerned workman, and for which this way or that way his intention was to take revenge.
Yes, just a minute. Okay.
Then again he goes back on no FIR, Your Lordship. That way explained in our written statement that no revolver was recovered, the person had gotten away, so the FIR was. After that, Your Lordship. Now next page, 132, Lordship. It is to fourth line, Your Lordship. To that in reply to the charge sheet, the concerned workman took alleviate in support of his plea of innocence. Onus on him to establish. However, the question of establishing the defense comes in only when the charge brought against him is established beyond all reasonable doubt. Again, Your Lordship, this is totally against all here. We have to only prove it with preponderance of probability. This is not a criminal trial. In the same way, onus absolutely rests on the management to establish the charge against the concerned workman delinquent. It is seen that with view to establish the charge, management have been able to examine one witness, that is Mr. N.K. Gupta. This is incorrect, Your Lordship. We have Ajay Kumar also, we have R.C. Singh also, who according to them was the person on the spot at the time of the incident in question.
He was the only person who was there on the spot. Rest of the persons were not.
So R.C. Singh was himself there.
Yes, R.C. Singh was certainly
there. Then here I would submit, I have given those judgments also, Your Lordship. Honorable Supreme Court has clearly said there is no allergy to hearsay evidence also in these kind of proceedings, provided it has an excess with the event, Your Lordship. I have placed those judgments also. I have placed the judgments, but I have given the comparison. Apart from the evidence of N.K. Gupta, management also examined one security officer, Ajay Kumar, whose evidence I have discussed in details above. He cannot be considered as an eyewitness as because of the fact that he was not present on the spot at the relevant time of the incident. It's not required, but yes, he was not there. This witness also in the course of his evidence admitted this fact. It is evident that only Mr. N.K. Gupta, but also many other persons were present. Again, he goes back to this.
Yes, respondent. What is he doing? He is reappreciating the evidence and coming to a different conclusion. What is the perversity in the matter of appreciation of evidence?
Then here one more thing I would like to place with Your Lordship's permission. Page 123. The inquiry officer has totally forgotten either or did not consider necessary to follow the principles of natural justice. My Lord, when my inquiry has been held to be fair and proper, and the power of
He is coming up with a
yes, and
further plea that it is violative of natural
page
justice.
the middle of this.
Page 133.
133.
The inquiry officer has totally forgotten
either or did not consider necessary to follow the principle of natural justice.
question of believing or disbelieving the alibi only would come after establishing of charge.
And again, page 13 also says all violation of principle of natural justice. Then, again, this is very peculiar, page 13 bottom. I find no hesitation to show that such order of dismissal issued by the disciplinary authority was neither justified. This much also if he had stopped, but it was nor proportionate to any offence committed by him. If the offence has been committed without the pointing of a revolver, then there is a disproportion here. And my lord, here, if required, I will produce certain. My lord, there are major discrepancies in the petitioner's statement. At one place, he says, I was unwell. I first went to the dispensary of the hospital of the company, but still I continued to be unwell. Then I went to the Dr. Saha's nursing home. Another place, he says, I went home. I felt so ill that I lost consciousness. My brother took me. When I came to, then there are major
The
discrepancies.
statement recorded before the inquiry officer. Where is the finding of the inquiry officer?
My lord, that is in the inquiry report.
Inquiry report. This is at,
Inquiry
is it at
report.
page 101?
It starts from page 101. Now here they have also one part. This starts from page 102, 103. Workman's case is discussed.
104.
104, the analysis starts here. Analysis at point 6 is important, but I'll place.
Para 5.
Para 5 years.
Shri Dharam Singh.
I am a disciple grade 2 as a year. Produced in the form of certificate from a private nursing home that he was admitted in the said nursing home from 8 p.m. of 18/6/94 to 7 p.m. of 19/6/94. He has also taken the stand that he had taken some medicine from the Bilakad feeder hospital, that is our hospital, on 18/6/94 at 7 p.m. and that even after taking the medicines, since he did not get any relief, he got himself admitted in a private nursing home. Next, however, the concerned staff of my staff of the feeder hospital, namely Titus C. George, who was present in the hospital at the evening of 18/6/94, has stated that the medicines were given for the wife of Shri Dharam Singh and not for Shri Dharam Singh. His contention is supported by the entry in the casualty register. So that part the learned industry tribunal has totally ignored. And the discrepancy I can show, if your worship permits, from the evidence of R.C. Singh of the Dharam Singh. My lord, if I am permitted to first place the reply.
His plea of alibi was rejected completely.
Here, my lord, page 56 is reply to the charge sheet. He
Yes,
says,
I've seen.
and then when he gives witness, he says something else over to the at page 56, he says that I may mention that I was on duty on 18/6/94 from 8:30 to 1 p.m. And the evening I got loose motion and pain in my abdomen. Since I have faith in Dr. M.P. Saha, MBA of number 5 Saha Nursing Home, Chataparan, Malkera, Dhanbad, I went to his clinic and he got me admitted in his clinic. He gave me a treatment and released me on 19/6/94 at 7 p.m. This is the reply to the charge sheet. And then when he gives witness, he says, I was not feeling well because of loose motion and therefore I went to the feeder hospital at 6:45 to 7 p.m. where I was given 2 tablets and 2 white tablets and then I left for my home. I took the medicine, but since I could not control my loose motion and my condition further deteriorated, and after that, I do not know. Next day, when I got up, I found myself in the nursing home of Dr. Saha. On query, I came to know that my younger brother took me to hospital. So this is the statement during the inquiry. Therefore, absolutely different. Now, our report shows that the medicines were given for his wife. He went to the feeder hospital, he put some medicines for her. So these are the facts, Your Lordship. After that, if Your Lordship wants, I can place a judgment for it, Your Lordship.
You just place one judgment, best one.
Quite a few of them, they are on different points. I've given a compilation, Your Lordship. The first one is at page 13. Page 13, Your Lordship.
13.
Yes, Your Lordship.
1 to 6 is Usha Breko.
Usha Breko, yes, Your Lordship.
This is from page 1.
Yes,
Relevant
page
is at
13, page 13, para 33. Before a department proceeding, the standard of proof is not that the misconduct must be proved beyond all reasonable doubt, which is what the industry tribunal says we have failed to do. But the standard of proof is as to whether the test of preponderance of probability has been met. The approach of the Labour Court appeared to be that of the standard of proof on the arraignment was very high. Here it does not appear to be. They have very clearly said in the statute that you have to prove it beyond all reasonable doubt. When both the parties had adduced evidence, the Labour Court should have borne in mind that the onus of proof loses all significance for all practical purposes. The next judgment, Your Lordship, is over judgment but still holds good. It is well said, page 19. Page 19.
Yes.
It is well settled that in a domestic inquiry, paragraph 4, Your Lordship, the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence. That's what the learned institute has said, that our security personnel was not a direct. I say that he was not a direct. But I am covered by this. Provided it has reasonable nexus and credibility. But when a person is threatened, he will definitely run to the security department. After that, Your Lordship, the next judgment is along the same lines. One important judgment, Your Lordship, is from page 35. I invite Your Lordship straight away to page 39. My paragraph.
Page
39.
paragraph.
Para 8 is again the state of Haryana versus Ratan Singh, which I placed just now, the second judgment. That is considered. Now, para 9 is very important. From the above, it is clear that once a domestic tribunal, based on evidence, comes to a particular conclusion, normally it is not open to the appellate tribunals and courts to substitute their subjective opinion in the place of the one arrived at by the domestic tribunal.
That's right.
This one is there, Your Lordship. Then after that, on the now, I'll skip some. The judgment at point 8. Here also the Honorable Court doubted the claim of the workman that he had gone and gotten himself admitted to a hospital when better facilities were available in house. This is at paragraph 13 of this judgment, Your Lordship, page 70 to 80, page 13.
Page?
My Lord, page is 77. Contrary to findings of the disciplinary authority, the High Court accepted the version of the respondent that he fell ill and was being treated by a local doctor without assigning any reasons. It was held by the disciplinary authority that the unit had better medical facilities. This we are not on. This claim of his has to be looked upon with a suspicious eye. It was further held that the letter did not produce any evidence of treatment by a local doctor. This is the point I was discussing here. After that, the next judgment is from page 81, paragraph 28 and 29. That is incidentally of this court. Here on page 91 and 92, paragraph 28 and 28 I was saying. Usha Greco, Your Lordship, it starts from page 98. It's a very short 2-page judgment. My Lord, page 100. This is an important judgment. First page. The Labour Court did not take any evidence or did not direct the management to adduce evidence before it to sustain the charges framed against the person. Obviously, it was because of its own conclusion that the domestic inquiry was valid and proper. So, no occasion arose for the Labour Court to ask itself the question whether on the evidence the charges have been proven. Now, next paragraph after that, Your Lordship. While considering the quantum of punishment,
Page 99, you are reading
page 100, page 100, it's the first paragraph, page 100. The Labour Court did not take any right at the top.
Yes, yes.
After this, Your Lordship, page paragraph 4.
Yes, I am reading.
Your Lordship.
Yes, I am. Even while considering the quantum of punishment,
Yes.
thereafter it has proceeded to record finding that the management has not proved the charges levied against it.
In the last judgment, paragraphs 19 and 20 at page 111, it is only on the point that no Labour Court or industrial tribunal has power to review effectively what they have done is reviewed their own order of finding my domestic inquiry to be fair and proper, and held that my proceedings were not as per the principles of natural justice, although the word review has not been used.
But once it is held that it was fair and proper, it goes without saying that it is as per natural justice.
My lord, and I would like your lordship, but the finding is that it was not as per natural justice. And they have-
And that finding that it was fair and proper, they have not filed any reputation.
They have not
They
filed.
could have done it. Even at this stage, they could have done it. Because these utility orders are all subject to final
My
result.
lord.
Yes, what do you have to say?
There is no eligibility in the order passed by the landed tribunal of legacy. If the employer has acted in gross violation of the statutory provision of the natural or the violation of the natural justice, or is guilty of victimization or unfair labor practice, the tribunal has the power to interfere.
What all are the circumstances in which the tribunal can interfere? Natural
Gross
violation of
statutory provision
statutory provision,
or the violation of principle of natural justice. That's
violation of natural justice,
or is guilty of victimization
guilty of victimization
or unfair labor practice.
or unfair
In
labor
all these
practice.
circumstances, the tribunal has the power to interfere with the.
Now let us come one by one. Is there any violation of statutory provision recorded by the Learned Court?
Yes, Lordship. Will guide this.
Which is that statutory provision which has been violated as per the Labour Code statute? First, tell me which is that statutory provision which has been violated.
Ladies, in this case, there is a violation of natural justice.
That is not a statutory provision. That is a natural justice
Yes.
violation. So no statutory provision. Statutory means provided under the statute, right? So there is no violation of any statutory provision. So you are trying to link it with natural justice because as per the statute, it has to be governed as per the natural justice. Fair. Now,
Lordship,
the domestic inquiry has been held to be fair and proper.
Lordship, at the preliminary point, was disposed of in the favor of the management.
Yes.
But the tribunal actually inquired finding that charge was unproved against the workman ladies.
So that is on merits. Natural justice is what? Some witness is there, somebody is to be cross-examined, or some document is to be produced. These are the processes of natural justice. Right? There is a clear-cut finding of the court that there has been no violation of natural justice as the inquiry is held to be fair and proper. Fair and proper means it covers natural justice. Correct? If it is fair and proper, then under such circumstances, where is the question of violation of any natural justice recorded in the final order? Where is that order by which the inquiry was held to be fair and proper? Have you annexed that order? That order is there?
Only the final award is there.
If the inquiry is fair and proper, there is no question of violation of natural justice. Isn't it?
Ladies, may kindly see page 133. The allegation which are brought against the concerned workman was very serious in nature, and therefore close scrutiny was expected on the part of the inquiry officer before holding the concerned workman guilty to the charge. It is seen that the inquiry officer, without scanning the evidence of the witness presented by the management, was very much busy to discuss with the alibi taken by the concerned workman. It reveals from his report how he found the concerned workman guilty to the charge as he failed to establish the LB taken by him. The inquiry officer has totally forgotten either or did not consider necessary to follow the principle of natural justice. Question of belonging disbelieving the LB only would come after establishment of charge brought against the concerned workman by the management. It is seen that the inquiry officer, without reading the evidence of management, witness properly, just relying on his finding relating to LB taken by the concerned workman, came to his conclusion that he was found guilty to the charge brought against the
Just a
other
moment. You are reading internal page? Internal page, which page of the award are you reading?
133. Under clause 9,
133. The allegation which was brought against the concerned.
yes, the allegation was brought against him. Paras second.
Yes. That I have seen.
In view of
So you want to say the inquiry officer has not considered the fact that he was otherwise proved guilty by the management or not, and the inquiry officer has only considered the point of alibi. Right? Let us see the inquiry report.
we can see page 104, the analysis of the inquiry order.
Yes.
From the above statement and evidence on record, the following have been revealed. The charge level against Sri Dharam Singh is that on 18/6/1994 he came to the pit-up at 15 feet silver with a revolver in his hand and put the barrel of the same on the chest of Sri R.C. Singh, assistant manager, and threatened him. From the management side, 3 witnesses have been examined. Sri R.C. Singh, the complainant, has testified that it was Sri Dharam Singh who came to the pit-up top and put the revolver on his chest. He has also stated that the incident was witnessed by Sri N.K. Gupta, another assistant manager who happened to be present at the pit-top at that point of time. Further, after having been treated by Sri Dharam Singh, Sri R.C. Singh rushed to the security control room and reported the matter to Sri Ajay Kumar, officer security, who was present at the security control room. Sri N.K. Gupta, who was an eyewitness of the incident, is named by Sri R.C. Singh, has corroborated the statement of Sri R.C. Singh that Sri Dharam Singh had come to the pit-top with a revolver. His presence at the pit-top with a revolver in his hand was confirmed by Sri N.K. Gupta. The third witness from the management side, namely Sri Ajay Kumar, officer security, has also confirmed that Sri R.C. Singh had gone to him at the date and time indicated by Sri R.C. Singh and reported about the incident. Sri Dharam Singh has, however, denied the charge. He has produced an LB in the form of certificate from a private nursing home to the effect that he was admitted in the said nursing home from 8 p.m. of 18/6/94 to 7 p.m. of 19/6/94. He has also taken the stand that he had taken some medicines from the Villatar hospital on 18/6/94 at 7 p.m. and that even after taking the medicines.
See, the entire evidence has been taken into consideration. There are corroborative evidence, and it is not only on the point of alibi. That finding is incorrect. That only the point of alibi has been considered. That is not the fact. There are 3 witnesses. Their evidence has been discussed.
There is more eyewitness present at this court.
It is another thing that how many witnesses are to be produced to prove a charge. You cannot dictate on the number of witnesses to prove the charge. The inquiry officer found the evidence of the witnesses credible, right? So, once the evidences have been found to be credible, their credibility cannot be discarded by the industry tribunal unless there is perversity in the matter of appreciation of that evidence. There is no such case.
Leadership may kindly see page 127. The learned tribunal observed that the management failed to substantiate the alleged misconduct against the workmen.
They have substantiated.
There is after the prosecution story. Paragraph. It is seen that over the said incident, no FIR was lodged against the concerned workmen at local police station. Considering the court, I have failed to find out any complaint or any written complaint lodged by the complainant, Mr. RCC, over the incident in question. Learned advocate for the management has failed to satisfy this tribunal in course of hearing if any written complaint was submitted by the complainant, Mr. RCC, to the management over the incident in question. Therefore, it is seen that without lodging any FIR.
Aside, even if there is an incident, is it necessary to lodge an FIR?
Yes, let us see. It is well settled law that the serious charge involving criminal misconduct cannot be sustained merely on assumption without supporting evidence. एक serious allegation है.
क्रिमिनल चार्ज नहीं कर रहे हैं ना ये इन्वेस्टिगेशन इनका क्रिमिनल चार्ज का नहीं है. They did not lodge an FIR.
At least written complaint तो देना चाहिए.
कहाँ है आप कुछ हमको दिखाइए कि बिना रिटन कंप्लेंट के और बिना FIR के इंक्वायरी नहीं हो सकती. Have you got any such judgment?
Yes, ladies.
Which is judgment? That without any written complaint and without any FIR, the domestic inquiry cannot happen.
Leadership, I will place it tomorrow. Leadership.
Tomorrow?
Yes, leadership.
Okay. Place it tomorrow. That without any written complaint or without any FIR, no inquiry can be. So the entire inquiry is vitiated in absence of a written complaint. This is what you want to say. Isn't it? ये जो नेचुरल जस्टिस का आपका इंक्वायरी वाज हेल्ड टू बी फेयर एंड प्रॉपर, तो इसका इस ऑर्डर का क्या होगा?
एटलीस्ट एफआईआर या रिटन कंप्लेंट रहता तो वो जो पिस्टल का बात बोल रहे हैं वो टॉय पिस्टल था या रियल पिस्टल था, एटलीस्ट उस पे इन्वेस्टिगेशन होता. वो पिस्टल रिकवर भी नहीं हुआ लीडरशिप. और लीडरशिप में काइंडली सी द क्रॉस एग्जामिनेशन ऑफ Shri Ajay Kumar by Shri Dharam Singh. Question number 4. Can you say whether any of your security guard had seen me entering and going out of Siswa Karwari? तो अजय कुमार जो सिक्योरिटी गार्ड है वो बोल रहे हैं कि no one had seen me. मतलब लेडीज अगर वो भाग रहे हैं, मान लीजिए वो जगह रिवॉल्वर दिखा के अगर वो वहाँ रहते तो
एलिबी का तो प्ली आपका रिजेक्टेड है. एलिबी के तो प्ली आपका रिजेक्टेड है. ठीक है, एलिबी का प्ली तो आपका रिजेक्टेड है.
इसमें लीडरशिप कोई
वी आर टेकिंग डिफरेंट स्टैंड एट डिफरेंट पॉइंट ऑफ टाइम. आप जो बहस की है आपके रिटन नोट्स में लिखा है?
नहीं लीडरशिप, इसमें कुछ और न्यू पॉइंट मिला है. पार्ट कर दिया जाए उसको.
पार्ट नहीं करेंगे आप, बस आपको जो अगर मान लीजिए कोई जजमेंट आप देना चाहते हैं तो आप दीजिएगा. वी विल कंसीडर इट. हियरिंग इज कंक्लूडेड. यू कैन फाइल योर रिवाइज्ड रिटन सबमिशंस इफ यू वांट, and you can also file if you want to tell me whatever you have argued. You can just, or I will dictate it.
but I will लीडरशिप इसको परसों रख दिया जाए. इसमें कुछ और हमको रिटन लीडरशिप सिर्फ एक बार क्योंकि 2005 का लीडरशिप केस है, ये बहुत पुराना केस है लीडरशिप. इसमें वो जो वर्कमैन
2005 में आपका एनरोलमेंट हो गया था.
नो लीडरशिप
आपके एनरोलमेंट के पहले का केस है, इसीलिए
लीडरशिप
पुराना
बहुत पुराना केस. लीडरशिप में वर्कमैन रिटायर्ड भी हो गए हैं. लीडरशिप काइंडली सी पोजीशन लीडरशिप वो
अब रिटायर्ड हो गए हैं तब क्या ही मिल सकता है हमको? 25% पैकेजेस.
लीडरशिप एटलीस्ट मेरा पॉइंट को प्लेस करने के लिए बस परसों एक टाइम दे दिया जाएगा. लीडरशिप इतना दिन से केस चल रहा, बस एक टाइम दे दिया जाए.
हमारे यहाँ कितना दिन से चल रहा है? पिछली बार तो आप आए भी नहीं थे।
आए थे लेडीशिप
हमें नहीं आता थे वन पर्टिकुलर केस रिपीटेड
लेडीशिप
परसों नहीं, कल सुनिए। अब इतना
लेडीशिप का हम आउट ऑफ स्टेशन
ये तो बहुत ही खुशी की बात है। नो, फिर आज ही कंक्लूड करें, ऐसा नहीं होता।
अच्छा लीडरशिप का नहीं कर दिया
ये इसमें मिस्टर मिश्रा, यू जस्ट लेट मी नो कि इसमें कौन से जजमेंट का कौन सा पैराग्राफ आप you have given the paragraph number of
Yes,
each
in the last page, of my written notes of argument.
Okay.
If you want to see that, or the paragraph number 20, I guess given page 11, your worship,
Page 11. No, you have not given the list of
judgments.
List of judgments, right?
Within brackets, paras 33, 36, 37, the case.
And what I have done in WPL 7795?
My lord, WPL 7795, your worship, has under those particular paragraphs,
Yes.
which I have been relying upon.
Principle of law has been called out.
Yes, your lordship, that is.
But the case was decided against the management or the
Yes,
government?
I know. Badriala, no, it was decided by the Para 28 and 59. Well, it was decided in favor of the government. In view of the first fact or circumstances, though this court has held that the finding of the learned labor court that the reference was not maintainable is perverse. Still, the petitioners will not be entitled to any relief. The finding of the learned labor court on merits upholding the domestic inquiry as fair and proper, and upholding the order of dismissal of the concerned workman by the management by scrutinizing the records in terms of section 11A of the Act and rejecting the plea of discrimination and victimization of the concerned workman does not suffer from any perversity or illegality. It was decided to my favor. I have mainly given this judgment.
That principle has been considered.
Yes, Firestone and all the relevant para 28 and 29.
लीडरशिप जजमेंट का कॉपी मिल जाता है
हम ले लेते हैं
एक पूरा बंडल दे दीजिए।
पूरा दे
The learned counsel for the petitioner has concluded his argument. The learned counsel for the opposite party workman has submitted that, has inter alia submitted that in absence of any written complaint or even an FIR, no proceeding, no domestic inquiry could at all be initiated. Right? He submits that he shall try and find out a judgment on this point.
Any serious allegation of criminal case?
That will explain in our written statement why we did not file it.
अब आया आदमी भाग गया तो क्या ही कोई करेगा कंप्लेंट?
So at least एक रिटन कंप्लेंट होता है उसमें इन्वेस्टिगेशन होता है उसको पता चलता है।
ठीक है,
लीडरशिप
we will consider that. आप आ जाइएगा।
लीडरशिप अगर परसों के लिए हो पाता है
परसों नहीं होगा, जब तो आप आ जाइए।
लीडरशिप हम फर्स्ट टाइम हम एडजर्नमेंट मांग रहे हैं, हम पूरे इंटायर केस में एक बार एडजर्नमेंट नहीं मांगे, बस परसों के लिए कर दिया है। लीडरशिप रिसर्च भी करना होगा, बस एक डेट बस परसों के लिए।
At his request, pose this case day after. You be there, Mr. Manish. Don't be absent.
Okay.
You judgment के लिए इसको पार्टेड कर देना। फर्स्ट केस है परसों हम लोग कोई और नहीं रखे ना ऐसा केस, चेक करिएगा।
केस है WPL 70 of 38 एक केस है
WPL है ना
जी,
तो फर्स्ट अपील हम लोग देख रहे थे कुछ
तब तक
कल।
Under heading for judgment, item 1, second appeal 102 of 2025.
This appeal is dismissed.
Item 3, WPL 5599 of 2015.
The labor board which has passed this order at the outset, and in view of the earlier order passed by this court in this case.
Earlier order passed by this court in this case.
Yes, LCR was called for this. What happens?
LCR has come. LCR is here.
Appreciate. Two IAs were filed and moved and order has been passed. But in that view of the matter, now petitioner cannot be allowed to contest the case on merit since there was possibly available to the earlier order.
Order date.
18/11/25. IA number 15290/725.
18/11.
Yes.
Yes.
Some case has been stayed on the explanation that the payment to the laborers will be made, personal labor to next order, 15 January 2026. Pursuant to the order dated 18/11/2025, 15 January 26.
Yes. Yes.
So this order was passed on the IA number 547. Now is kindly come to the the annexes.
The amount was to be sanctioned, no?
Yes.
Yes.
The annexes that
So
itself
we are talking
kindly see.
about the amicus settlement which was about to take place. But on the last occasion, the stay was taken back, and I have made a submission that I have.
Submission is not sufficient. Kindly see, madam. The annexes appended to the I number 457 of 2026. And answer 1. Answer 1 is the order of 18/11/25. Then answer 2, that is a letter written by the chief engineer मुख्य अभियंता to the सरकार के अवर सचिव जल संसाधन विभाग झारखंड राज्य। क्या लिख रहा है? उपयुक्त प्रासंगिक पत्र के क्रम में इस कार्यालय के आदेश क्रमांक 1439 दिनांक 17/12/25 से गठित समिति द्वारा सिंचाई कामगार यूनियन मुख्य अभियंता परिक्षेत्र जल संसाधन विभाग देवघर के साथ हुई बैठक के उपरांत अधीक्षण अभियंता सिंचाई अधिकारी के पत्रांक 3 दिनांक 6/1/2026 से दिनांक 6/1/26 को आयोजित बैठक की कार्यवाही और यूनियन से प्राप्त सामूहिक आवेदन की पूर्ति संबंध का आवश्यक कार्रवाई हेतु प्रसिद्ध की जाती है। जैसा क्या अनुरोध है ये kindly see the signature of 14 persons.
though there are 6 respondents in this case.
Where is the ultimate compromise?
Then, and you see that then next page, answer 4, there is a letter written by the Adhichan Abhiyanta, Mukhya Abhiyanta. WPL में दिनांक
उनको तो पावर है इस तरह से कॉम्प्रोमाइज करने का. Where is the ultimate compromise? Where is the seed?
Letter was written to the
Letter
government.
must have been written,
There was written to the
but
government.
it did not crystallize as a compromise.
सरकार के अवर सचिव के पास चिट्ठी लिखा, उस चिट्ठी awaiting for allotment of fund.
And sanction also. Sanction बिना मिले फंड आ जाएगा.
So
When you talk about compromise,
So
you tell us where is the compromise?
then there are another letter, Adhichan Abhiyanta letter.
Letter मत दिखाइए, आप हमको दिखाइए where is the compromise in writing.
5 officers of the respondent and of the operational company. Then next page 17.
Yes.
माननीय उच्च न्यायालय झारखंड राज्य द्वारा WPL 5599/2015 में दिनांक 8/11/25 को पारित न्यायाधीश के आरोप में मुख्य अभियंता जल संसाधन विभाग देवघर के पत्रांक स्वयं 100/25 द्वारा गठित समिति एवं सिंचाई कामगार यूनियन मुख्य अभियंता परिषद से जल संसाधन विभाग देवघर के दिनांक 6/26 को आयोजित बैठक की कार्यवाही. This it has been signed by 5 officers of the prisoner. सर्वप्रथम दिनांक 23/12/25 को पूर्वाह्न में 11 बजे मुख्य अभियंता जल संसाधन विभाग देवघर के निरीक्षण भवन के बैठक आयोजन की गई. इसमें सभी गठित समिति के सदस्यों ससमय उपस्थित होकर बाद में संबंधित अधिकतम स्थिति की विस्तृत चर्चा की गई. दिनांक 27/12/2025 को गठित समिति के सदस्यों एवं सिंचाई कामगार यूनियन के साथ सिंचाई अंचल दफ्तर कार्यालय में बैठक बुलाई गई तथा माननीय उच्च न्यायालय झारखंड द्वारा पारित न्यायादेश पर समझौता की दिशा में विस्तारपूर्वक
सहमति प्रदान करने के लिए भेजा गया. कुछ नहीं है. This is all.
so my submission will
आप-
not say
Yes.
that
Submission rejected.
whatever the either this petition is allowed or the it is dismissed. What will this
This is of no consequence.
not this workman but they
आप तो बहस ही नहीं करने दीजिएगा उनको कि अब इनका केस डिसमिस कर दें. आप तो भी ये 20 लाख
No,
20
हम
करोड़
circumstance
20 लाख
को-
रुपए circumstances.
circumstance come कर रहे थे. These are the circumstances. And I was just gonna
The settlement did not reach to a logical end. Even the last document is saying that it will be sent for approval. Approval हो गया. इतना आसान है. Compromise approval हो जाना सरकार से.
is the it has come with the order.
सरकार is the biggest litigant.
It has come with the order.
ऑर्डर शीट में आने से डॉक्यूमेंट दिखाइए ना. ऑर्डर शीट में लिखने से थोड़ी हो जाएगा.
It is
सरकार is the biggest litigant. आपको क्या लग रहा है यहाँ खत्म होगा? कहानी सुप्रीम कोर्ट में जाके खत्म.
हम इसीलिए compromise पर request कर रहे हैं.
Compromise has not
For
reached.
the reason
Compromise has not reached. Should I draw an order to that effect?
government has been
There is no approval. There is no final approval of compromise.
let the our सचिव जल संसाधन उनको कुछ लिखा कि what
It has not
order
yet
in
come.
past which will be conducted the party and notice will be issued. Is the future of these
Ma'am, it is
parcels.
What happened
Oh,
thereafter?
only 6 are
After the
there.
matter was sent to the secretary judge.
We have either some with that.
That's
Sorry?
why I would
It was.
मैम ये ऑर्डर कभी भी ये कॉम्प्रोमाइज कभी भी सैंक्शन हुआ नहीं.
नहीं तो कहाँ से बोल रहे हैं? Because there is an order drawn by 5 officers that it will be placed before the competent authority.
It was placed before the
From where do you say?
the document which he read.
Yes, the document which is read is that it will be placed before the competent authority. What happened thereafter?
I asked the executive about this, but the matter was never yet compromised. It was never reached to a conclusion. They are saying that the matter should be this as for in merits, and no compromise should be take place. As we
Okay, you argue the case on motion. चलिए, बहस करिए.
वो क्या हिसाब हुआ
Sir, अब बैठिए.
21 लाख एंड और उसको 20,000 में हम लोग बोला अच्छा 20,000 में हम लोग मान गए.
अब आप पूरा पैसा नहीं
20
दे
लाख.
सकते. अब बताइए क्या कहना है?
The
Where is the amount?
at page number 76 of the award. From para 2, I want to give this question. May I
Page
take
number
this?
76.
Page number 76. Of the award.
Page number 76.
76 of the award.
Of the award means the award is running in 100 pages.
No, the running page of my petition.
Page number
Page number
76.
76.
Yes.
Para 2. May I read this one? The Chief Engineer Water Resources Department, Deoghar, booking number 1, has filed the written statement, and there he has stated that the reference is not maintainable and time barred, as the workmen were disengaged in between 1994 to 95 and 95 to 96 after compliance of section 25F of the ID Act. He has further stated that the department is not an industry in the ID Act, and the workman has no legal right to reinstate it or made permanent as they were daily wage workers and never appointed in terms of relevant rules. He has also stated that on daily wage, the workmen were engaged in between 1982 to 87, and subsequently, due to lack of funds, their services were not required. He has also stated that the workmen cannot claim regularization because they were not engaged after following the process of advertisement. OP2, the Chief Engineer Water Resource Department Deoghar and Executive Engineer Jamtara have also filed written statement making similar statement. And three, the workmen have stated in this written statement that they were engaged in the services against vacant posts and they were posted in different divisions. Subsequently, 29 workmen were removed from services without proper notice, and in Secretariat Division, out of 35 removed workmen, 24 were taken back in service. Out of that, 24 workmen, 12 are in the reference, and 17 other workmen working in different divisions were removed from services in 1996 without giving any notice. Compensation and back wages. Again, 12. Out of 29 workmen were taken into services, but rest 17 were not taken back, nor any payment is made. Out of 17, 2 workmen, Srimati Jitani Medrini and Sri Jagdish Das were dead. I have further stated that the workmen had worked for more than 10 years and their termination without notice, compensation and back wages was illegal. They have also stated that the heirs of dead workmen are entitled for back wages. I have further stated in that 2 workmen were not regularized despite urgency and request the government by the department. They were not paid back wages. They have prayed for reinstatement of 15 alive workmen and payment of all dues, and also for regularization of 12 other workmen working in the department and payment of their wages. The workmen involved in the reference are Rameshwar Malik, Jakit Naran Shamasar, Jagdev Ramani, Kapildev Ray, Ashok Kumar Sar, Rajan Rajwar, Dev Narayan Yadav, Ratan Kumar Singh, Abdul Hamid Khan, Sanjay Goswami, Bhim Narayan Dubey, Umesh Chandra Mandal, Shiv Lal Hemram, Bablu Saha and Ratan Ram. From initial or written statement filed on behalf of the parties at dispute, it appears that there are 2 main questions involved in this case. They are: first, whether Water Resource Department is an industry under the ID Act, and second, whether the termination of workmen in 1994, 5 and 1995, 96 was legal. Both the sides has led evidence on the point. Let us discuss the matter according to evidence and credits available on record. Para 6. In written statement, the Water Resources Department has said that the department is not an industry. Subsequently, the department has also stated that before termination of workmen, the department has observed section 25F of ID Act. When the department was not an industry, why it has observed the provision of compensation provided in ID Act? Section 2I of ID Act defines the word industry. The same word industry with same meaning is mentioned in section 25F of ID Act. According to nature of work, construction of barrage tunnel for flow of water and making arrangement for irrigation, it is clear that the unit is engaged in construction work and the work done in this unit falls in definition of industry. From perusal of record, it appears that in preliminary inquiry, the fact is already considered and the court has already concluded that the department is an industry and the reference is good. Therefore, the only question remains to decide whether the termination of survey department was legal and if not, what remedy they have. On the first issue, ma'am, I am raising my point that it is not an industry. It was earlier also decided by this honorable court only. It's the judgment which I have supplied. If this department is not an industry, then how the labor court has jurisdiction to pass such an order?
Which judgment are you relying on?
That is the judgment passed in WPL number 6857 of 2016, passed by this honorable court. I am requesting this court to kindly come to para number 6.
It is with respect to the same department, same place?
Same department, ma'am. Same department. May I read the para?
minor irrigation.
This is not minor irrigation, this is judgment. May I read the para 6?
ये है सिंचाई विभाग
सिकाटिया देवपुर. The only fact is this is with regard to reference number 3 of 2010 and the present case is reference number 5 of 2010. The matter was remanded back to the concerned labor court to decide on the point that whether this concerned department falls under the definition of industry under the ID Act or not.
So in the present case, they have framed an issue and decided. In this particular case, the labor court did not frame an issue.
Did not frame that.
But here they have framed an issue and decided.
But what the reason they have given?
So whatever be the reason, but there is a distinction between the two.
What is the distinction?
On the last date, you said that there was no such order.
That preliminary order.
Yes. There is no such order.
Which we have not formed. I have sent them a notice to serve me a copy of this, and they have replied that there is no such preliminary order exists in the records. That's why the NCR was called for.
The matter was sent for adjudication by your government only. The matter was sent for adjudication by your government only. Isn't it? You yourself had sent the matter for adjudication to the labor court. It is your reference, isn't it?
The reference was filed on a recommendation of a letter.
सरकार के अवर सचिव, राइट, झारखंड अधिसूचना के द्वारा औद्योगिक विवाद अधिनियम के धारा 10 के अंतर्गत इस न्यायालय को न्याय निर्णय हेतु प्रेषित किया गया.
Many workmen have approached the government. They are requesting the court to institute this case as they have been terminated in the year 1995, but after the lapse of 15 years.
That is a separate thing.
But ma'am, whether it is an industry or not, the person who the respondents who are claiming that it is an industry, they have to produce evidence with regard to that. I'm just requesting this court, let this matter be remanded back to the concerned neighborhood court to decide on this point only.
The arguments have remained inconclusive. Post this case, no further arguments. Tomorrow we have posted one case, and either that one or this one will be taken up as the first case. Tomorrow.
सर फर्स्ट कॉपी है
वही फर्स्ट अपील कौन सा आपको याद नहीं है?
166 167 ये मिस्टर सुजीत सिंह
श्रीजीत चौधरी. That matter is already parted, right? Only short argument is to be heard in that. ज़्यादा नहीं है उसके बाद. ठीक है. इसको जोड़ना. जो परसों गया उसमें डाल दीजिए.